the restaurant, and of course, that's about it.
All on CRN. Don't miss it.
And welcome. It is time for Richard Nixon Live, broadcasting coast to coast and around the world. We're going to discuss all the important legal issues with renowned constitutional scholar, lawyer, attorney, Juris Doctorate, Richard Nixon, physicist as well. We are so happy to be here in studio with Richard. Make sure to check out his website. Go to crntalk.com/Richard Nixon. Also make sure to keep those emails coming, richardnixon@crntalk.com. Today we're going to be talking about a host of legal issues. We're going to be talking about the exclusionary rule. We're going to be talking about also the big news this week of the retirement of Justice Kennedy and the how the confirmation process might play out and all that. But Mr. Nixon, thank you so much for being here.
Thank you. Glad to be here.
All right. And I believe you wanted to, as always, just to kind of set the tone, maybe we want to talk a little bit about the Declaration of Independence.
Yes, we should. For those of us who feel compelled to have some justification for criticizing our government as opposed to criticizing our country, I'd like to repeat again, as we did last week, a portion of the Declaration of Independence, which was, of course, penned by Thomas Jefferson in 1776. And very briefly, let me just quote, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men." So let's stop there for a second and reflect on that. It basically means that the government didn't give us these freedoms, this life, liberty, and property, and the pursuit of happiness. The Creator did. And the government's only function, frankly, its only proper function, is to secure the rights that the Creator gave us, and to continue that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it. And I think in some small way my book likes to point to the situations where our Supreme Court has fallen and not lived up to its purpose as our government.
Very well said indeed, sir. We always like to start off the show with a great quote like that. It's just it's an important message that needs to be heeded. And if you want to find out more about that, make sure to check out Richard Nixon's fabulous book, America, An Illusion of Freedom. It's available on Amazon.com, and also you can get the links off our website as well. We're going to talk a lot about a little bit about criminal law today, which I'm kind of excited about because I'm not a kind of constitutional expert like you are, sir, but I get most of my legal knowledge from watching Law and Order. And, a common concept you hear about in Law and Order is the Miranda rights. Read them as rights. And there's it all stems from a case that came out of Arizona in 1965. It was Miranda versus the United States. And it set up, what you hear on all your favorite crime shows, be it, the right to remain silent and all those rights enumerated from that decision. But we're going to talk about that because I think there's something a little bit unfair about the exclusionary rule when it comes to evidence, and we're going to talk about that right after the break. Once again, give us a call, 818-818-6401. We'd love to hear your opinion about everything, and make sure to keep those emails coming as well. And check out the video feed. We are on video right now at the bottom of our website, crntalk.com. Just click live in studio, and you can watch us. So we'll be right back, you guys. Stay tuned. Back in one short minute with more with Richard Nixon live on crntalk.com.
I'm Richard A. Nixon, author of America, An Illusion of Freedom. When Congress in 1868 passed the 14th Amendment granting citizenship to children born in this country, it was intended to exclude children of foreigners and aliens, among others. It was never intended to include children of illegal aliens, as is now being misapplied. We can change that without a constitutional amendment by having the President alone or with Congress grants citizenship based on birth only to those whose parents are citizens. This would solve the current anchor baby problem. Your eyes would be opened as to how much freedom intended by the Founding Fathers has been lost to Congress and the Supreme Court, and how this can be reclaimed without a constitutional amendment. For more information or to order my book, America: An Illusion of Freedom, go to crntalk.com/Nixon. That's crntalk.com/Nixon. That's crntalk.com/Nixon.
And welcome back to Richard Nixon Live here on CRNtalk.com. That's CRNtalk.com. We're talking about all the important legal and constitutional issues. Make sure to check out his book, America: An Illusion of Freedom, available on Amazon.com. So, Richard, let's get down to brass tacks. I was watching Law and Order the other day, as I like to do. And they were reading them rights, reading as a suspect their rights. And, I've grown up with that. I've never really delved deep on where that came from. And I always thought it was, that's just how it was. That's part of the Constitution. It's part of the justice system. But it's really a relatively new thing in law, 1965, which is a relatively new thing, all things considered. Tell our audience what Miranda is and what the exclusionary rule is.
Okay, very good. As an introduction to this subject, however, I would like to mention the fact that one hears in the media constantly about truth in lending, truth in advertising, but the media is sparse on truth in adjudication. And the exclusionary rule, which came about or had its origin in the Miranda case, 1966, you said 65.
Oh, I did. Oh, I'm sorry.
Well, that's okay. We can differ on that. But anyway, at least in my book on page 90, it's got a date of 65, and you could be right that it has 66. Anyway, the whole point of the exclusionary rule is to somehow solve the problem where, if you will, the sheriff blunders. That is to say, defendant has been picked up in some kind of for a criminal offense. And because the sheriff or marshal or police kind of mistreat him, even if there's a trustworthy confession by the defendant, it's excluded. Defendant's counsel would bring a motion to suppress, basically saying, Your Honor, you can't permit this confession because the police messed up. But again, it confuses two things, trustworthiness and truth in adjudication, as I call it. And up until 1966, the Miranda case, there was a case in California, Adamson versus California, 1947, where the prosecutor and the court were permitted to state, in effect, that defendant is here, he knows whether he was at the crime scene or not, but he's refusing to take the stand. They commented on that, and the Supreme Court said that was perfectly valid for the prosecutor to use that, in essence, to infer that he must be guilty or he'd take the stand. As of 1966, Miranda basically took the Fifth Amendment, saying that you cannot be made to be a witness against yourself, and misconstrued that, added to that, made 4 or 5 sentences out of it, those same 5 sentences that you hear on the police show, saying that you do have a right to remain silent. If you say something, it can and will be used against you. If you need an attorney, we'll hire one, and so on. None of that is in the Constitution. It's made up by the Supreme Court.
Yeah, just some backgrounds about the case. This gentleman, Mr. Miranda, was arrested. I believe the arrest date was 65. I think that's why. And the Supreme Court adjudication is 66. He was arrested for kidnapping and rape, and he subsequently confessed. He signed a confession, a standard signed confession, and then after the fact, he claimed that because he wasn't told that he could have counsel available, that's what ended up going to the Supreme Court and started this precedent. It's very, very interesting, and subsequently he was retried and convicted. So yes. just a background there. And the exclusionary rule, I wanted to probe this a little bit because I think that the intent is important. No one wants to go back to the bad olden days where you can take a rubber hose or a sap to a suspect,
Shoot, exactly.
and and beat a confession out of them, suffice to say. But what the exclusionary rule does is, even if there's a smidgen, and even just a smidgen of perceived impropriety, that whole thing can get thrown out. What does they call it? It's fruit from the poison tree, they say.
Right.
And so I think what's important about your point is that when there's included in what is the term inculpatory evidence that is discarded just because of one small technicality.
Yes, and if we're going to pretend that a lawsuit, especially in a criminal context, that we're trying to get to the truth, that is to free a person who's innocent and prosecute a person who's guilty, it makes no sense for the jury to not be privy to a valid and otherwise trustworthy confession. And if the police mishandled the defendant in somehow, from one degree to another, it's, in my mind, it's certainly proper. And every other, quote, civilized country does just that. They allow the confession to come in if it's trustworthy. That is to say that this defendant knew details that only the defendant would know. And the police also mistreated him in some way, that both of those issues are presented to the jury, and the jury can decide to what extent they're going to hold this defendant liable. And one of the strongest arguments against the exclusionary rule is the fact that what about the family of this daughter or this girl that was raped?
Yeah.
Are they going to look to our justice system and say justice was done when they could not use his confession against him when they raped this father's daughter? I think it's untenable and it should be reversed.
And how would we go about that?
Well, again, it's up to Congress. Again, I think last week we touched on Article 3, Section 2, Paragraph 2. Congress can pass any law they want to and simply withhold jurisdiction from the Supreme Court to hear it. So Congress could say simply, from this date forward, the exclusionary rule no longer applies, that we will institute so-called truth in adjudication. And if the phrase they use is the sheriff blunders, if the sheriff blunders, then we'll prosecute or punish the sheriff as well. But both bad guys, both miscreants, will be treated under the law, and no more, let's say, untruth in adjudication.
I think the sheriff's blunders as a theory is interesting to me. I also think that it's important to protect suspects' rights. I think that's important.
Absolutely.
It's an important concept. I also think it's a very, very important point you brought up, and just something that I wholeheartedly agree with, that these issues, these sheriff's blunders, should be adjudicated by the jury.
Exactly.
Not by the judge. It should be all those factors, should be taken into account in the jury room, and then the jury can make a decision themselves. For example, if they thought perhaps that this confession was coerced from a suspect that maybe was mentally incompetent.
Exactly.
There's been there's a famous case, the Brandon Dassey case out of Minnesota that's been in the media recently, where they believe that a confession was coerced from him because he had limited mental faculties. But once again, the jury should be able to decide that.
Yes. In fact, you bring up an excellent point, and that is when the attorney brings a motion to suppress, it goes to the judge exclusively. The jury is not privy to it. And so it's the judge who now is privy to this, quote, confession, who suppresses it so that the jury never hears it. And that's exactly the point, that you've got a judicial officer preventing the jury from adjudicating the truth.
Absolutely, and that's what we want here. Is we want the truth. That's what the justice system is for.
Exactly.
Is to provide truth to the people. We'll be right back, you guys. A lot more to talk about. This is a fascinating topic. Richard Nixon, a constitutional scholar, legal authority, as well as a physicist and just a amazing man. We'll be right back, you guys. Stay with us. 3 minutes. Talk about a lot more about what's going on with the legal issues, constitutional issues, and more. I'll be right back.
Hi, friends. This is Larry Manetti. Go to LarryManetti.com to get my book, Aloha Magnum. You'll read all about the wonderful guest stars like Carol Burnett, Elvis Presley, Frank Sinatra, and many, many more. There is an episode guide and my favorite recipes that I really cook at home. I will include a free signed photo with every book. Get Aloha Magnum at LarryManetti.com. Order now. Aloha.
When you really want Italian food, you've got to go to Columbo's. Columbo's Italian Steakhouse and Jazz Club, Colorado Boulevard, Eagle Rock. It's that little neighborhood place you wish was down the street from you. Can you believe that Independence Day is right around the corner, and right around the corner is Celebration City, Columbo's? So show your independence, fly the flag, and scream to the heavens, be gone, corporate eateries. My choice is Columbo's. No corporate script from your waiter saying, "Hi, I'm Florence and I'll be your server." No, no, no. It's honest, friendly service, sizzling steaks, magnificent offerings from the 7 Seas, Columbo's family secret Italian favorites, jazz every night, and to that we say, yes, yes, yes. Isn't it time you get acquainted with the Columbo's experience so you too will exclaim to one and all, yes, 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 because it really is that little neighborhood place you wish was down the street from you. Declare your independence. Columbo's. Mangia.
Do you want to fly somewhere, anywhere in the world? Smart travelers call myflightsearch.com for the best deals on flight tickets. Going to Manila, Bangkok, London, how about Singapore? Call myflightsearch.com for the lowest flight tickets available. What about a local vacation? Let's say you want to fly to Vegas, Orlando, Miami, Los Angeles, or Denver. Pick up the phone and call myflightsearch.com right now. We have exclusive deals that you can't find anywhere else. The only way you can get these low airline prices is by calling us. We have so many low prices available, we can't possibly tell them to you right here and now. If you're flying somewhere anytime in the next 6 months and you want the lowest airline ticket prices anywhere, you owe it to yourself to save a ton of money. So pick up your cell phone and call myflightsearch.com right now.
Call 800-445-3166. 800-445-3166. That's 800-445-3166. Call now. 800-445-3166.
Destination South Point. 11 great restaurants, bingo, bowling, movies, race books, sports books, spa, live entertainment, oversized rooms, and the rates unbeatable. The South Point Las Vegas. Book now. Online at southpointcasino.com or call 866-791-7626. southpointcasino.com or call 866-791-7626. At the South Point Las Vegas, you're always a winner.
And we are back. Richard Nixon live here on CRN Digital Talk Radio, broadcasting coast to coast and around the world on CRN Digital Talk Radio. And before the break, we were talking about the exclusionary rule and truth and adjudication.
Right.
Which I think is the overall arching concept about this. And, you know, you printed out some amazing material here about in criminal law. And it all comes back to the Fourth Amendment, doesn't it?
It does.
Yeah.
Well, and yes, and oftentimes the Fourth and Fifth Amendments are interwoven. Just as an example, the actual, from the Miranda case, 1966, or 65, as Mike likes to tell me, the Fifth Amendment, the portion that we're discussing in the Miranda case was that portion that says no person shall be compelled in any criminal case to be a witness against himself. Now, that presumes that an active case is, or a case is active, and that when the prosecutor calls a witness, he cannot call the defendant to testify against himself. Now, that's clear, but you see what the Supreme Court did in that case is they went pre-arrest, pre-custody, and pre-interrogation. That is, when the police or whatever authority is to enforce the law, when they first come upon this potential defendant, they're then told that they must tell him he has a right to an attorney. So this goes way outside. This predates any kind of criminal case proceeding. This is the main objection to most people that have read the Miranda case, because from that scanty phrase that says no person shall be compelled in any criminal case to be a witness against himself, from that the Supreme Court rewrote it and said, In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privilege must be observed. Number one, person in custody must, prior to interrogation, be clearly informed he has the right to remain silent, that anything he says will be used against him in court. He must be clearly informed that he has the right to consult with an attorney, and that if he can't afford an attorney, that one will be provided for him. Now, my point in saying all that was that is all rewriting of the Fifth Amendment. That is not in the Fifth Amendment. Those are the words of the Supreme Court. And again, one of the things that I rail against in my book is simply that the Supreme Court's function is to not write the law. It's to adjudicate the law as written, in this case, by our founding fathers in the Constitution.
And we were talking during the break. Interpretation is such such a slippery slope when it comes to the legal field. You can pick out any little thing.
Absolutely.
Any little thing a defense attorney can pick out and run with it,
exactly,
as you might say. I remember particularly a case I was reading about recently. It was concerning the Wonderland murders, a notorious case back in the late 70s, early 80s in Los Angeles. And one of the principal suspects, there was a big issue in his trial. I believe there was multiple motions to suppress and dismiss because there was a Bible present in the interrogation room. The suspect asked for a Bible. They brought him a Bible in. They weren't reading from the Bible. It was just there on the table. And then they proceeded to extract a confession from him. And
yes,
this defense attorney said that was below board.
Yes.
It's just, it's amazing.
That I must confess I'm not entirely privy to that case, but it certainly makes sense. And again, our whole point today in talking about truth and adjudication is not that we're also holier than thou, but the point is if we're going to pretend to do justice to a person, and by do justice I mean if a person is innocent, then that person should go free. If the person is guilty, he should be or she should be punished. Consistent with that is that we not allow a judge to prevent the jury from hearing all the facts surrounding, in this case, a criminal case.
And I think that's important. We need to say that justice is a two-way street, that we need to consider justice for the defendant, and we also need to consider justice for the victim.
Exactly.
Because oftentimes what happens is that these trials, can go on for years, motion after motion after motion, and that family is left really just withering in the wind, waiting for some sort of closure.
Yes, that's absolutely true. And again, getting back to, you had mentioned the Fourth Amendment, which is part of what we said in the statement, that recently the case, the Carpenter case, is a situation where Chief Justice Roberts said that it was a violation of the defendant's Fourth Amendment freedoms to allow information regarding his phone use to be used against him to show that he was a defendant in a robbery.
Absolutely. I want to talk about the Carter case right after the break. It's a fascinating decision and has a lot to do with electronic privacy, but also as justice as well. So you guys stay with us. We'll be right back right after the break. More with Richard Nixon Live on CRNTalk.com. That's Richard Nixon Live at CRNTalk.com. Make sure to check out his book, America, An Illusion of Freedom, available on Amazon.com. We'll be right back right after the national break, 4 minutes.
Trying to sell your old car? Instead, donate your vehicle to Heritage for the Blind. Pickup is free, and your donation is tax deductible. Just call 1-800-785-9618. Heritage for the Blind accepts cars, vans, trucks, and boats, whether they run or not. Call right now and receive a free 3-day vacation voucher to over 50 locations. Call 1-800-785-9618. Donate your car today. That's 1-800-785-9618.
From traditional Hawaiian weddings and vow renewals to your own unique ceremony, find out why Ka'anapali Weddings is the perfect place to say, I do. Create the memory that will last a lifetime at the place you and your family know and love, Ka'anapali Beach Hotel. Imagine yourself and your loved one just steps away from world-famous Ka'anapali Beach in one of many wedding venues to choose from, including oceanside lawns, tropical gardens, or indoor banquet rooms. With your choice of catering, bar, floral, and musical options, you can make your special day customized just for you. Their wedding specialist will help you plan your dream wedding today. For more information, visit Ka'anaPaliWeddings.com or call 661-0011. Ka'anapali Weddings, the perfect place to say, I do.
Ka'anapali Beach Hotel, Maui's Hawaiian Hotel.
The smartest way for you to get the lowest prices on your plane tickets, domestic or international, is to call SmartFares first or last, but you've got to call us before you book your plane tickets. Fly anywhere in the world, fly anywhere in the U.S., and SmartFares can save you up to 75% on your plane tickets. We have the lowest airline ticket prices on over 500 airlines, and you've got a great 12-hour free cancellation window. Plus, with our live agent help, you can always get fast help and fast answers. So on your next trip, maybe today, maybe tomorrow, how about right now? Pick up your phone and call SmartFares, plus save up to 75% on your plane reservation. So call right now. 800-915-2644, 800-915-2644, 800-915-2644, 800-915-2644.
You order a glass of your favorite Cabernet, fresh asparagus, hollandaise on the side, a filet, medium rare. You unfurl your napkin with a flair, close your eyes, and prepare to listen. Ah, there it is. The sweet music you long to hear. The sizzle. The sizzle of a Ruth's Chris steak.
The most magnificent corn-fed prime beef, broiled to perfection at 1,800 degrees. Some call it a sizzle. We call it an anthem.
As the waiter approaches, you think, is this one mine or that one?
Ruth's Chris Steakhouse. Like Ruth always said, life's too short to eat anywhere else.
Make a reservation online at ruthschris.com or by calling 800-544-0808.
America's 242nd birthday is next week, and we're celebrating outdoors. Joining the revolution with Jim and Trav to kick off the 4th of July in outdoor style is Taylor Drury of Critical Mass, Pigman from Pigman the Series, ranch hands Jerry Courtney, and Josh Atkinson and Trent Cole of Blitz TV, presented by Cabela's. We're outdoors and freedom bound this week, and presented by Outdoor Channel, Sportsman Channel, World Fishing Network, and My Outdoor TV. Saturday mornings at 7 o'clock Pacific Time on CRN Digital Talk. CRN 2.
And we are back. Richard Nixon live, broadcasting coast to coast and around the world on CRNtalk.com with a noted constitutional scholar, Richard Nixon. We're talking about all the important legal issues in America today. And an important case was adjudicated by the Supreme Court recently that we need to talk about, the Carpenter case. It's a case that's very, very important for someone like me who's a mass communications background, because electronic privacy is an important tenet of mass communications. But it's interesting. This is a very interesting case, Richard. Can you give us kind of the background on it?
Yes. Mr. Carpenter was one of a revolving set of, we'll call them defendants at this point, who in the Detroit, Michigan area were robbing different locations, cell phone, T-Mobile, and Radio Shack, and other places. And one of the ways the prosecutor used to locate Mr. Carpenter and his allies was by his use of his cell phone. Apparently, whenever a person powers up their cell phone, there's a signal sent to their cell phone provider, and it's indelible. It's there forever, so to speak. And over a period of a year or so, he had something like 11,000 different stamps showing where he was. And for the purposes of the prosecutor, they were able to show that almost every time that he was near a particular location, there was a robbery at that location. So they used this information to convict him.
And I just real fast to clarify for our audience, it's not like he was being tracked by his phone's GPS. That's not
That's right.
That's some CIA stuff. What they do, which is very, very common, it's a technology called a triggerfish, I believe, where you can triangulate a phone signal based on the cell phone tower. So
right.
Go ahead.
Now, again, this particular cell phone location index is only accurate within several blocks, if you will. It's not like GPS where it's reliable up to about 15 feet, as I understand. But in any event, what the Chief Justice said is that according to the Fourth Amendment, which says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, what the Chief Justice wrote, along with the four more liberal of the justices, basically said that that information should be suppressed because they violated his Fourth Amendment freedoms. That is what I just read, the Fourth Amendment, his right to be secure in his house, papers, and so on. And I was amazed to see that there were four dissents, all four of the more conservative justices, extremely articulate and showing that, in fact, the Fourth Amendment was intended to protect, in this case, Mr. Carpenter's house, papers, and effects, not the phone companies. In other words, that information did not belong to Mr. Carpenter. Therefore, he had no claim to say that his rights had been violated.
Yes, if you actually, if you bother, and a few people do, to read those voluminous agreements you sign when you get your cell phone service, they own that data. They own that data. And this is also, it's very interesting we bring this up, the Fourth Amendment, how they applied it to this case, because the right of the people to be secure in their persons, houses, papers, and effects, this was in public. This man, they used the telecom company's infrastructure.
Yes.
And I'm not familiar with this. Did they need a warrant or a subpoena to get this information?
That's what's interesting too. In the four dissents, they claim that Chief Justice Roberts conflated subpoena and warrants. That is to say, and a subpoena is something that's done pretty commonly in a regular criminal case, like in this case. You simply ask the judge for permission to subpoena certain records. If this were a dissolution action, for instance, over child support, you could get bank records, you could get employment records, and you go right to that third party because that third party owns those documents. Yeah. And the defendant, if you will, has no right to block that. Now, that's what the dissent said in this case, is that Mr. Carpenter had no right to object to this because this property did not belong to him.
Yeah.
It belonged to the phone company.
Yeah.
But the majority opinion written by Justice Roberts basically said that under the case called Katz, which is also a 1966 case, I believe, basically said that the Fourth Amendment protects people, not places. And therefore, wherever this person went, the Fourth Amendment tracked him. And it's because of that he could object based on the Fourth Amendment.
That's very interesting. That's actually fascinating. I do know that, because subpoenas for records, you can go to your mobile company for the subpoena, and you can get the call logs, the actual call logs. If you want to actually listen to those phone calls, you need the warrant. I'm interested, Richard. We talk about, a big crux of your book is about the politicization of the Supreme Court, how they've really become the de facto executives in this country now because they can make law.
Well, that's right. And again, that's exactly what's happening. Each of the four dissents said roughly the same thing in different ways. And that is now we're hopelessly confused now because now we don't know whether or not we need a warrant or just a subpoena in order to get these run-of-the-mill records.
And I think the affirmants, the other justices that were in support of this case, I think that their politics is showing. I think that this decision, and hey, I'm not saying that I agree or disagree with their politics. Yeah. I'm apolitical. I don't even vote.
Yeah.
I think, there's been a lot of stuff in the news, especially from the left, about Facebook, about privacy, about electronic surveillance, about all that. And I think that, those justices were, reading the tea leaves of what's in the media recently and what the political winds are blowing.
Yes. And again, the whole purpose of a subpoena is to shed light on the evidence of the case. Once you get the subpoena, it might turn out that the defendant is correct. That is, that the documents don't support either the prosecutor or the plaintiff's counsel. So it's kind of an intermediate discovery step so that the investigating agencies can find the truth, if you will. We're back into this truth thing, and find out whether or not they want to go forward. Where a warrant is very extreme, you have to show a very, very high level of security that you're going to prevail. And what they're saying is Mr. Chief Justice Roberts confused the two between a subpoena and a warrant, he should have permitted the subpoena.
Yeah, the standard of burden of proof is
Exactly.
far less rigorous for a subpoena than it is for a warrant.
Exactly.
You definitely have to have a pretty strong amount of probable cause from that. This is fascinating. I love talking about this kind of stuff, Richard. You guys, we'll be right back. We're going to talk about the Supreme Court more. We're going to talk about the retirement of Justice Kennedy, and perhaps what the Supreme Court really needs is a different system for appointing new justices, and I'd like to ask Richard his opinion on that right after the break. You guys, stay tuned. Richard Nixon live here on CRN Digital Talk Radio. We'll be right back in 2 minutes.
I'm Richard A. Nixon, author of America: An Illusion of Freedom. If you're sick and tired of having 9 unelected Supreme Court justices running our country, nullifying our votes by finding things in our Constitution that don't exist, and ignoring things in our Constitution that do exist, in short, if you're sick and tired of their rewriting the U.S. Constitution, and you want to do something about it, read my book, America: An Illusion of Freedom. It shows that beginning in 1803, the Supreme Court has been rewriting, distorting, and intentionally misinterpreting the Constitution to the point where 9 unelected lawyers in robes are in charge of our freedoms. You will be shocked when you read how the 14th Amendment has been misused, but also how easily it can be fixed. For more information or to order a copy of my book, America: An Illusion of Freedom, go to crntalk.com/Nixon. That's crntalk.com/Nixon.
If Ernest Hemingway was alive today, would he say this to you?
Shakespeare, Mark Twain, Edgar Allan Poe, all great writers. And after reading your book, I simply must add you to the list.
Wait, you don't have a book yet. So make a free call to Page Publishing. Their expert staff can help you turn your book idea into a real book, a masterpiece that could someday make the bestseller list in hard copy and digitally all across the world. Page Publishing can help you completely take your idea for a book, write it, and publish it. So if you want to join the ranks of some of the most famous authors in the world, call now for a free information kit. Turn your book idea into publishing gold. Make a free call right now to Page Publishing.
800-378-3212. 800-378-3212. 800-378-3212. That's 800-378-3212.
And we are back. Richard Nixon live, broadcasting coast to coast and around the world on CRN Digital Talk Radio. That's crntalk.com. Make sure to check out his book. It's absolutely fantastic. America: An Illusion of Freedom, available on Amazon.com. And so some news of the week. Big news out of the Supreme Court. Justice Kennedy is hanging it up. He's retiring at the age of 81. He has been known as the swing vote of the court these past couple terms. He has started his career somewhat conservative, but has moved a little bit more liberal in the last couple of years, sided with Obamacare, I believe, the ACA, and a couple other decisions. Richard, a big part of your career, you spent a lot of time and a lot of energy focusing on the Supreme Court and how the Supreme Court has become the de facto leadership of this country because they make law from the bench. And so my question to you, sir, is there any way we can depoliticize the Supreme Court?
Well, yes. In fact, Thomas Jefferson was president in 1803 when Chief Justice Marshall took a lion's share of the power in the Marbury versus Madison case to determine, frankly, what laws Congress enacted would be constitutionally appropriate. There is nothing in the Constitution that even suggests that the Supreme Court was intended to be the superior of the three. In fact, the Federalist Papers that you had mentioned earlier all talk about co-equal branches.
Yeah.
If that's the case, as Thomas Jefferson said in 1803, each can determine its constitutionality within its own sphere. It was never intended that, in this case, the Supreme Court determined constitutionality for Congress, for instance. And again, if one thinks about that for a second, Congress is supposed to reflect the will of the people. And if the people agree that whatever Congress did is constitutional, even though they're not experts, Jefferson and many people believe that over time people will eventually do the right thing. That is to say, so many people in the judiciary believe that they can't trust the people. The people might do something awry, and it requires this 9 sensible people to make these rational decisions. But they don't reflect on the fact that what if we had 9 individuals on the Supreme Court who were all half crazy?
Yeah.
In other words, if they were maniacs, theoretically, we're bound by what they do. So in answer to your question, there is a solution. And again, it's something that no one ever mentions, including Hannity, Rush Limbaugh, Mark Levin. No one mentions Article 3, Section 2, Paragraph 2, which basically says that Congress can at any time withhold jurisdiction from the Supreme Court at any time they wish. So they could pass a law limiting, that is to say that the Supreme Court cannot declare acts of Congress or any acts of the states unconstitutional as of this particular date, and they cannot hear this matter. It's finished, it's over, and the Supreme Court, that is to say, and Congress is in charge.
And so what would happen? What would the role of the Supreme Court be if that didn't happen?
Oh, they are perfectly free, like any other judge, to interpret the law, but hold it short of declaring the law unconstitutional.
I see.
You see, this is where Chief Justice Roberts got into trouble because people don't understand what he did. He said early on in the Obamacare case, where he found it was constitutional, he made it very clear that he was going to do everything he could to find it constitutional. That is the role of the judge, as opposed to overturning what the Congress did, because Congress theoretically represents the will of the people. Yeah. People don't appreciate what he did there. He didn't like Obamacare any more than the rest of us, but he felt an obligation to twist everything he could to find what these duly elected representatives of the people wanted. It was clear they wanted Obamacare, and he said, fine, we're not going to stand in their way.
And that's not a legal opinion, that's a political opinion.
Exactly.
And I believe the way he framed it is the ACA, the individual mandate, which was the section that was under discussion, was indeed a tax.
Right.
Rather than elsewise, and the president can levy taxes.
Well, he did it both ways. What he did is he first called it a penalty. He couldn't call it a tax because this, quote, tax was not due until 2015, and this case was heard in 2014. In order to object to a tax constitutionally, you must have paid the tax. Since the tax wasn't due till 2015, he called it a penalty. Now, once it was called a penalty, the court then had jurisdiction. Now, he said, for constitutional law purposes, it's a tax. So he did some gymnastics there, and everybody knows that he did that. I'm not convinced to this day that it was improper for him to do that, but what I am saying is he was on my side, so to speak, when it comes to the Marbury versus Madison decision. He was saying, we, the court, do not have the authority to overturn what the people wanted. They want Obamacare, and we're not going to be so arrogant as to reverse that.
You made me smile with that.
Yeah.
It's not you can't object to the tax until you've paid it. That's the government for you right there.
Yes.
That is
right.
the federal government indeed. We're having a good time here, you guys. Richard Nixon live. We're learning a lot. I'm learning a lot. It's this great legal scholarship I'm getting right now from Richard Nixon. I am Mike Gary, CRN Digital Talk Radio. Make sure to check out his book. It's absolutely fantastic. America, An Illusion of Freedom, available on Amazon.com. Just search the title. Also, you guys will be right back with more, wrap things up, and we're having a good time here in CRN Digital Talk Radio. Richard Nixon live. Make sure to check out the video feed at the bottom of our website, and the video will be available on YouTube within a couple hours. So stay tuned. We'll be right back right after the break. More with Richard Nixon here on CRN Digital Talk Radio.
You're experiencing pain, back pain, shoulder, elbow, or hand pain, pain from a sports injury. If so, schedule a visit with Dr. Michael Sheps, the leading expert in laser therapy for pain management. Call 310-873-4422 or go to drsheps.com. Experience Epic T, the breakthrough laser therapy system that Dr. Sheps developed to make you pain-free in less time. Laser therapy is a non-invasive, safe, and effective in-office procedure that penetrates deep into your skin without damaging the tissue. It perfectly targets areas of pain to promote fast, natural healing. Relax your muscles, ease muscle spasms, joint stiffness, and arthritis pain while increasing blood circulation. For over 25 years, Dr. Sheps has helped Olympic athletes and sports enthusiasts alike get back in the game. Schedule your visit with Dr. Sheps at his Brentwood office in California. Call 310-873-4422 or visit drsheps.com. That's DRSHEPS.com, 310-873-4422.
Do you want to fly somewhere, anywhere in the world? Smart travelers call myflightsearch.com for the best deals on flight tickets. Going to Manila, Bangkok, London, how about Singapore? Call myflightsearch.com for the lowest flight tickets available. What about a local vacation? Let's say you want to fly to Vegas, Orlando, Miami, Los Angeles, or Denver. Pick up the phone and call myflightsearch.com right now. We have exclusive deals that you can't find anywhere else. The only way you can get these low airline prices is by calling us. We have so many low prices available, we can't possibly tell them to you right here and now. If you're flying somewhere anytime in the next 6 months and you want the lowest airline ticket prices anywhere, you owe it to yourself to save a ton of money. So pick up your cell phone and call myflightsearch.com right now.
Call 800-445-3166. 800-445-3166. That's 800-445-3166. Call now. 800-445-3166.
Come to Angelo's and Vinci's Restaurante to see memorabilia of movie stars and theatrical magic right in downtown Fullerton, California. The Art of the Great Masters in an Italian town square complete with storefronts of old, Italian butchers and cheesemongers, fruit and wine vendors, seamstresses showing their wares, the romance of Romeo and Juliet. Find our mystical Room of the Moon, and don't forget King Kong, Dracula, Frankenstein, and who knows what awaits you in the wine cellar. Enjoy the great food. We hand stuff our pastas, roll each and every tortellini, bake our own bread, and make all of our sauces fresh from our private stock of Sicilian family recipes. Pasta to seafood, chicken to award-winning pizzas, tiramisu flowing in from Rome. If you can't find something on our menu to tempt you, you don't like Italian food. Try our Sunday brunch, all you can eat, just $21.95. And Angelo's and Vinci's has been named the best Italian restaurant in Orange County 2 years in a row, and our owner has been named Restaurateur of the Year. Angelo's and Vinci's, Fullerton, California, 714-879-4022 or angelosandvinci's.com.
And we are back. Richard Nixon live here on CRN Digital Talk Radio, streaming coast to coast and around the world. We are talking all things law today. And another important decision came down from the Supreme Court. President Trump's so-called travel ban has been ruled constitutional and therefore applicable in law. Initially, a judge, I believe in Hawaii, Ninth Circuit, perhaps?
I believe it was, yes.
Yeah, Hawaii deemed it unconstitutional, and therefore it went to the Supreme Court. Richard, what are your thoughts on that decision?
Well, actually, what happened in that case was there was an injunction that was issued to prevent the president from executing his third travel ban against 6 or 7 countries that the previous administration had already ruled. The people that would come from there that would apply for visas and so on had no documentation. So when they came to this country, we couldn't, if you will, vet them to see if they were good guys or bad guys. We had no way of examining them, investigating them. So President Trump instituted this travel ban, and based upon some comments he had made before he was president, they claimed that this was anti-Muslim and therefore was unenforceable. So what the Supreme Court did was simply set aside that injunction, that is to say that the travel ban can go forward. Now, technically, that case is still pending before that court, but at least the injunction is no longer there, and the president can go forward with it. And basically, this law that the Congress actually gave the president this authority, and most constitutional experts will say that where the Congress actually grants power to the president, his authority is at its zenith. That is to say, you can't find any more power because he hasn't taken power from Congress. He's doing it with the permission of Congress. And in that case, we permit, that is, this country permits the president to determine on his own who can come into this country and who can be kept out of this country for security purposes. That's the way it is. That is the law. And again, people try to confuse the matters by simply saying, well, he's only doing this because he's anti-Muslim. And of course, the court saw through that and said, we look at not the motivation for the law, we look at the law in its terms. Other presidents have used that same authority 34 times since 1952.
Yeah.
And therefore, suddenly now it becomes unconstitutional? No. So it's another victory for President Trump, and I think it's a victory for, again, truth.
It's I believe the court's decision was based in part on his role as commander-in-chief.
Exactly.
That it's the commander-in-chief's duty and role to protect the country and protect the nation itself, and I think that's how he framed it. I believe there was language in the majority opinion that they didn't necessarily, really relish the travel ban, but the powers enumerated in the Constitution as commander-in-chief, he has that right.
Yes, that again, but you see, that's fine because most judges that apply their role as judges properly recognize that wisdom is not within their purview. A judge might disagree vehemently with the law, but it's his job to effect the purpose of the legislature. If the law is very clear, the judge has no choice but to affirm the law and grant it.
Absolutely, because it all comes down to the people. It's the legislature. They're the ones that make the laws. The court system, the judicial system are the ones that should enforce and interpret strictly. And I believe that's a strict interpretation is what we're going for.
Absolutely.
All right, you guys, we're wrapping things up here. So just a heads up, we will be talking a lot more about the upcoming Supreme Court vacancy. I believe the president said he's going to announce his list on July 16th. And so I'm interested to see who the possible candidates are, and I'd love to hear your opinion on that. You guys, thank you once again for joining us. Richard Nixon Live. We are here every Saturday at 1 p.m. Pacific time, 4 p.m. Eastern time. Make sure to check out his book, America, An Illusion of Freedom, available on Amazon.com. We'll be back next week, you guys, with more. Thank you so much for joining us here. Richard Nixon Live on CRN Digital Talk Radio.
Which was most appropriate because that was your theme.
Are you tired of hearing your favorite talk radio shows sound like this? What if you could hear your favorite shows in crystal clear, high-definition digital sound? Well, with CRN Digital Talk Radio's 6 channels of high-definition radio, you can now hear all of your favorite hosts like you've never heard them before in CRN HD. The difference is amazing. Catch your favorite political hosts like Dennis Prager, Tom Hartman, Barry Farber, and so many more. Entertainment and lifestyle programming like the Robert